All right, good afternoon, everyone. Thank you so much for joining us during Ethics Week. I'm Nicole Allen, and you are here for social media and the Freedom of Information Act in 2020. So it's 2 o'clock, so we'll get started. Thank you, Ashley. Could we go to the next slide? So if anyone can't hear me clearly, please send me a note in the chat. And I'm going to be going through this presentation, and at the end, I'll take questions. So whenever you are asking a question, which will be at the end, if you're doing it in the chat, make sure that you addressed it to everyone so I can see it, or in the Q&A section. So with this presentation, I'm going to start with an introduction of our office. I'm going to move on and discuss a little bit about government record keeping. Then I'm going to talk about some recent cases. I'll go on to discuss social media policy and policy making. And then I'll conclude with some notes on document retention or record retention in social media. Next slide. So who are we? So I am the director of the DC Office of Open Government. We are an office within the DC Board of Ethics and Government Accountability, or VEGA, as we're known as. And our mission is to ensure that government ethics, openness, and transparency is taking place in this virtual world that we're now operating in according to DC law. The Office of Open Government enforces the Open Meetings Act, and we provide advice concerning the implementation and compliance with the Freedom of Information Act. So we provide advice to you all, which would be FOIA officers. We provide government agencies, government directors. We also provide advice to the public. And the DC law authorizes us to issue advisory opinions to give formal FOIA advice. So if you're in need of an advisory opinion on a particular issue, or you'd like us to take a look at a matter, please contact us. Next slide. So I assume most of you are FOIA officers or are familiar with FOIA, but I'll go over this anyway. The Freedom of Information Act is the law that gives the public the right to access information from the government. Under FOIA, government agencies must release information that is requested unless that information is protected from disclosure. And as you all already know, there are also affirmative disclosure requirements within FOIA, so you should be providing information to requesters that fall into a specific category without a FOIA request. Next slide. So the Federal Freedom of Information Act, on which our law is based, was enacted in 1967, and it gives citizens access to public information held by federal agencies. FOIA applies to federal agencies, but most states, including the District of Columbia, have their own versions of an Open Records Act. DC FOIA was enacted in 1973, just 7 years after its federal counterpart. It gives any person the right, upon request, to inspect records held by public bodies. And that term includes DC government executive agencies, independent agencies, other governmental entities, and the DC Council. It's interesting, and you should note the date of when DC FOIA was enacted, 1973. I'll give away my age. I was born in 1974, so DC FOIA is a year older than I. And when I came about in 1974, we lived in a completely different world. So now this FOIA that was enacted many years ago has to deal with technology and the newest advances in how we're doing business, especially how we're doing business virtually in DC. Next slide. So social media is complex from a legal and policy standpoint. So I'm going to be going over the intersection of the two when it comes to FOIA. We as a government are increasingly relying on social media to do our business and communicate with the public. And there are responsibilities concerning public records that tie to social media now that we're using it as a tool to communicate and to do business. Managing social media content from a record-keeping perspective is paramount to maintaining transparency and being able to comply with FOIA requests for information. So let's dig back to 1973. For those of you who are old enough to remember, you had paper files, you had file cabinets, you had carbon copies of documents, which are a paper laid over carbon paper. So the framers or the drafters of the 1973 Act, this is what they had in mind when they were talking about producing documents. It was literal. It was something that you could put your hands on and go get documents and records. So now, since our record keeping is in this virtual world, we have to somehow make sure we're still complying with the law and making sure that the public can be confident that when we're making these records online in the virtual world, that they'll have access to them. Next slide. So the way we interact with the public has transformed. And FOIA law has adapted to technology. So as you all know, email is big for us in DC government. It's taken care of primarily by the Office of the Chief Technology Officer as from a storage standpoint. So just like I want you to keep email in mind when thinking about social media. So just like email, social media content can be considered a public record. So public correspondence, public business meetings, correspondence, and the like that happen on the social media site are likely considered a public record subject to FOIA law. A lot of us, as we're doing now, we're having meetings. So a lot of the content of this meetings could be subject to FOIA, depending on what we're doing and the communications that we're having. Next slide. So now I'm going to talk about the government's electronic record retention responsibilities. Next slide. So I'm looking at social media as a record. So it is well established that state and federal FOIA laws require governments to retain and produce electronic records. As I just mentioned, email is a key example. Social media accounts and government social media accounts may constitute records of the conduct of government business that must be preserved and produced under FOIA. Next slide. So the preservation of digital content is key. So there's some content that we have as an enterprise that we are retaining, and there are others that we have to have the responsibility as record keepers to do that on our own agencies. So when emails, texts, and social medias are used to conduct government business, they must be archived and pursuant to DC government laws. Next slide. DC FOIA gives the public the right to inspect, request, duplicate public records. So we define our public records as all books, papers, maps, photographs, cards, tapes, recording, or other documentary materials, regardless of physical form or characteristic, prepared, owned, or used in the possession of or retained by a public body. And in DC, as we know, public records specifically include electronic records. So an interpretation of the law would say that social media sites are electronic records. The rub comes with social media because it is a fluid space. So the thing that we have to attempt to do is to capture social media content in a space and time. So as FOIA officers, you know that that's what the request is for. It's for a specific range of time, it's for a specific date. So with social media, since it is fluid and changing, that can be a challenge. Next slide. So as you know, DC may look to other jurisdictions as instructive on how to deal with social media records. So I'm going to take a look now with you regarding how other states' FOIA laws are dealing with social media. I'm going to look at Texas, Massachusetts, Arizona, and Georgia. Next slide. So in Texas, they modernized their law in 2013, and they provide that electronic communication is under their public records law, and they defined it as the general forms in which the media containing public information exists include email, internet posting, text message, instant message, and other electronic communication. Texas further clarifies that under their social media guidelines, content posted by the agency or the public on an agency's social media website is a state record and is subject to state records retention requirements. So in Texas, it's clear that social media is a record that must be preserved and produced under their public records law. Next slide. So the next slide deals with Massachusetts. Massachusetts public records law defines public records as all documentary materials or data, regardless of physical form or characteristics, made or received by any officer or employee of the Commonwealth or any political subdivision thereof, municipalities as an example, unless such materials or data fall within one or more of the exemptions of the law. This definition includes electronic documents and other data. So we could see it's similar to Texas, that regardless of physical form and characteristics language is key to, as we said earlier, molding this new form of media into our 1960s, 1970s FOIA law. Massachusetts also acknowledged in its electronic records management guidelines, public entities that use social media should be aware that most social media sites are hosted by third-party providers. Therefore, public entities need to ensure that procedures are implemented to preserve social media in light of this problem. So the issue here and the issue with social media is that, again, its content is controlled by the state government, but it's on a platform that's not a government platform. So in Massachusetts makes it clear that although it's not on a local government platform, that the government is still responsible for managing this content, and goes further as it shouldn't rely on Twitter or Facebook or any other social media platform to retain that information. So in Massachusetts, it's more of a affirmative obligation to preserve that record. Next slide. So now we're looking at Arizona. So in 2015, the Arizona State Attorney General said that Arizona public officials' text messages and social media activity are a public record if the information is related to their official roles. And they say electronic messages sent or received by a government-issued electronic device or through a social media account provided by a government agency for conducting business are public records. And I think it's valuable when a state government lays that out because it sets forth the expectation of government officials when using devices and when using social media accounts. Next slide. So lastly, look at Georgia. The Georgia Open Records Act states public access to public records should be encouraged to foster confidence in government. This means all public records should be made available for access when an open records request is made. In fact, Georgia's Open Records Act specifically addresses electronic messages, whether in the form of email, text message, or other format, as a public record. So that includes public social media. That includes social media. So we see that many states are grappling with this issue, and it is essential for our laws to catch up to technology. And when they don't, it's important for us as FOIA officers and open records professionals to make sure that we know what's going on in neighboring jurisdictions so we can advise our agencies and our agency directors on how they should be conducting themselves and how they should be preserving these fluid records. Next slide, please. So next I'm going to talk about 3 recent social media cases. They deal with Facebook and Twitter. Next slide. So the first case is West versus City of Puyallup. So the Court of Appeals in Washington State held in 2018, we confirmed that a public official's post on a Facebook page can constitute an agency's public record subject to disclosure under the Public Records Act if the posts relate to the conduct of government and are prepared within a public official's scope of employment or their official capacity. And the citation is there. So I'm going to go into a little detail about the case. I put a link in the chat to this presentation, and it contains my case notes that I'm going to be going over in these next couple of slides. And it also has a link to the actual case. So in West versus City of Puyallup, this case is about whether posts by an elected official on her personal Facebook page are public records subject to the Washington State Public Records Act. In this case, Arthur West made a public records request for records related to a city council member, Julie Doerr's Facebook page. The lower court in this case held that the personal Facebook page was not subject to the Public Records Act, even though the owner of the page was an elected official. The Court of Appeals affirmed and articulated the following standard. A public official's post on a personal Facebook page can constitute a public record if, 1, those posts are related to the conduct of government, and 2, are prepared within the public official's scope of employment or official capacity. The court held that the city did not prepare the Facebook post at issue here because the council member did not prepare the post within the scope of her employment or official capacity as a city council member. She was not conducting public business or furthering the city's interest by the Facebook post. So here are some more facts of this case. So West submitted a public records request to the city and asked for all city-related public records sent to or received at Councilmember Doerr's Friends of Julie Doerr's Facebook site between 2014 and 2016, or any such records in possession of the city. So the city conducted a search of its official Facebook page for any records sent from that page to the Friends of Julie Doerr Facebook page, and it located no such records. The city also searched its archiving system for all documents sent to and received with the term, quote, Friends of Julie Dorr, and located one message to a city email address inviting the recipient to like the Friends of Julie Dorr Facebook page. The city produced a copy of that message to West, and the city disclosed no other documents. So West, who is the requester, filed a public records action against the city, alleging that the city violated the Public Records Act by not disclosing posts on the Friends of Julie Dorr Facebook page. The city argued that the posts were not public records. The city submitted a declaration that stated, it was from Dorr, that stated the page did not contain any information related to the conduct of city government, business, or the performance of any government function. She explained that the Facebook page was not used or intended to conduct any government function and had not been used or referenced by the city at city meetings or cited in support of any agency action. She also stated that the page was publicly accessible and that the account had only received one immaterial private message. Finally, Dorr stated that the page, which is something we should keep in mind here in DC, was a campaign site used for campaign purposes and to support and to give information to her supporters. So she's arguing that the Friends of Julie Dorr site was not a government site. It was a site that was essentially raising money and providing information to people to elect her to office. The requester, of course, disagreed with the city. He provided the court with publicly available posts from this Facebook page, and he argued that the information was, in fact, related to city business and public comments before the city council. So the posts that he provided fell into three general categories. First, several posts referenced issues that the city council was considering, information about public events, links to council documents, and a city council meeting agenda. Also, the next category, several posts contain links to the city's official Facebook page and posts about various issues, including information about a special meeting. And the third category, a few posts reference and contain links to the Puyallup Police Department's official Facebook post. In addition, the Friends of Julie Dorr Facebook page contained comments from individuals regarding a few of the posts. Dorr did not respond to the comments, and she did something which I would recommend that all public officials do. She posted a message on the page after West's request, stating that she was prohibited from answering specific questions about the city's actions on Facebook, and that all questions should be directed to her work-related email address and work telephone number. So the court examined this information, and even though they found it related, information related to city business on the Friends of Julie Dorr website, the court found it to be important that it was not prepared by Dorr in her official capacity, so it was not a city record. The court stressed that if the posts were made in her official capacity, it would be a record. So it was significant that this website, although she was a city council member, was put together as part of her campaign. The court also relied on two cases that held an elected official's text messages on a private cell phone were public records when they were prepared in the owner's official capacity, and held that emails on a personal email account are public records if they meet the criteria for a public record. So as DC is clear on these issues with respecting text messages and information on private cell phones. So, I would go so far as to opine that this case would be applicable to DC FOIA, and if there was a request to a government agency for a government official's information on a government official's election-related page, then that would not be a city record, a DC record. That would, in fact, be a private record. Next slide. So the next case, Johnson versus the CIA. So the Massachusetts Federal District Court held in 2018, the agency is required to search for and produce the record even though it is hosted on Twitter's website because the agency has sufficient control over the document. So the plaintiff in this case sought records pertaining to CIA's Twitter account at CIA. The plaintiff, Dr. Amanda Johnson, was a PhD candidate at MIT and a research affiliate with Harvard University when she made this FOIA request. She sought several records related to the Twitter account, including emails, documents, training materials, and the like. Most relevant to our discussion topic today, she sought a list of user applications connected to the CIA's public-facing Twitter account. This information is stored on the @CIA account page on Twitter and can only be accessed by logging on to the Twitter account. So the CIA denied this FOIA request. It had conducted a search of its own records and did not conduct a search of its Twitter account for the requested list. So it relied upon Twitter as the custodian. It responded to the FOIA request stating that it did not possess the requested records. So the court found the CIA's search to be inadequate. The list that the requester sought was on the agency's Twitter account. So the agency controlled the Twitter account and should have searched for the record on Twitter. The court reasoned the makeup of the requested list of applications is controlled by the agency's own decisions with regard to the Twitter account. This shows that Twitter has significantly relinquished control over this page to the agency. Even if not hosted within the agency's record system, the agency has enough ability to manipulate and use the record so that the list constitutes an agency-controlled record for FOIA purposes. The court in this case ordered the CIA to produce the requested list. So the rule that we can take out of this case is that even if information requested is not for a particular tweet or content that's public-facing, if you have control, if the agency has control over that information on the platform, even if it's something that's behind the scenes, then that agency control is sufficient enough that they should be able to produce the record. And next slide. So the next and final case is Davison versus Randall. The U.S. Court of Appeals for the Fourth Circuit affirmed the decision of the district court finding that the Loudoun County School Board Chair Phyllis Randall's Facebook page constituted a public forum and that she did not maintain it in a lawful manner. So this is a case concerning a public official's Facebook page. The Fourth Circuit affirmed the district court's judgment concluding that the chair of the Loudoun County Board of Supervisors violated the First Amendment rights of one of her constituents, Brian Davidson, when she banned Davidson from the chair Phyllis J. Randall Facebook page she administered. Davidson is a very active member of the community, and he raised ethical concerns about the school board. He basically alleged that they were taking kickback money, so he was blocked from commenting on the page. The court held that Randall acted under color of state law in banning Davidson from the chair's Facebook page, and the interactive component of the chair's Facebook page constituted a public forum, and the defendant engaged in unconstitutional viewpoint discrimination when she banned Davison's page from that forum. So this is not a FOIA case per se, but it's relevant to FOIA policy and to government transparency. The Fourth Circuit's view that Facebook is a public forum where free speech is permitted is something that the government of the District of Columbia must keep in mind. Also, responding to messages or taking action on social media in your official capacity as a government employee or an official is a state action that most likely must be recorded and preserved. So as you are a records professional, and a lot of you are lawyers, you need to make sure that you're advising directors and people who are in charge of social media pages and content that they cannot restrict access to that forum, and that people are commenting, although they may not like the comments, because it's a government-sponsored forum, they need to allow the people to comment. You can't block anybody. You can't delete anyone from these social media accounts that are controlled by the government from a policy standpoint. And again, if this type of activity is happening, it's probably something that record keeping is triggered. Next slide. So that is a good segue into the next topic, developing a social media policy. Next slide. Issues to consider. So when drafting a social media policy, you should ensure that, drafting a social media policy will ensure that the agency has proper procedures in place to retain social media posts and associated comments with respect to official agency as opposed to personal social media accounts. In these policies, you should clarify that the use of personal social media accounts, including campaign accounts, should not be used to create public records. The policy should also provide agency officials with guidance and employees with guidance regarding the best practices for their use of non-governmental social media accounts. Next slide. So the key elements of a social media policy notes that content posted to an agency social media account is a public record. So although DC law doesn't state that, your policy probably should give your staff and directors notice that they're creating a record. A social media policy should require agencies to maintain social media account content in accordance with your record retention schedule, which hopefully your agencies have. You should encourage posting copies instead of originals, public records to social media to avoid any retention problems. So that means a document or record that you are posting on a social media account should not be a true original. There should be a copy of it stored somewhere else other than Twitter, Facebook, Instagram, Pinterest, etc. I'm not sure if anyone's using Pinterest, but that would be interesting to know if the government was. Next slide. So the Office of the Chief Technology Officer has a social media policy on its website, octo.dc.gov, and you should make sure that as a records professional and FOIA officer, you are familiar with this policy. So in the next two slides, I think I'm just going to go over the permissible uses of social media as stated in that policy. And if you are an independent agency, you haven't adopted this automatically. It's something that you would have to proactively do. And if you are an independent agency, you may want to just draft your own policy, but know that the OCTO policy is there. So permissible uses of social media to engage constituents in real time and provide customer service, to promote thought leadership among DC government entities, to disseminate news and information and events, provide another vehicle for agency outreach, build real and virtual communities. Next slide. View and post content for research, communication, information exchange directly related to the mission, charter, or work tasks of a DC government agency. View and post content for research, communication, and information exchange for professional development, to maintain currency of training or education, or to discuss issues related to the Internet users' DC government activities. View and post content to build information exchange amongst residents and build communities around district service offerings and other government communications not requiring a high level of security. Next slide. So a DC government agency, excuse the typo there, considering establishing a Facebook, Twitter, or other social media account should first adopt or review OCTO's social media policy to govern the administration and monitoring of site content, or establish its own. Also, set ground rules for public input and comments, along with adopting policies for employee usage of social media. This is an instance, again, because it's new, I think it's important that internally, as an agency, that you set forth expectations about what's going on your social media sites. And again, the FOIA officers and public records officers should be providing guidance to whomever it is in the agency. It's usually the general counsel's office that is creating these policies for the agency. So I would request that you as FOIA officers find out what these policies are, and if they are not one, if you don't have one within your agency, that you kind of take the lead in making sure that this gets done. It's important, especially that we're finding ourselves in the virtual world, and I can tell you from the open government side of my office, several agencies are conducting Facebook Live and Instagram Live meetings, and there are comments and other things that are happening in real time. So having policies around what's going on there, I think in the long run will be of great value to you as a record keeper, and be of great value should a member of the public or someone else request a record regarding that use of the social media. Next slide. So again, what's posted on a government social networking site or social media site is public information. Do not post non-public information or information that is covered under a FOIA exemption on social media. That goes without saying, but you can't take it back. Once it's out in the public realm, it is out there, and that exception no longer applies. So if anyone else asks for it, you're going to have to provide it. If it's a document, if it's a recording or whatever, once it's out there, it's out there. So if you delete it and it was there, the exception does not apply anymore. So government agencies can avoid public confusion, lawsuits, and other problems with a strong social media policy. So again, I encourage you to look at what the Office of the Chief Technology Officer has set forth for you, but to not only rely on that, but if you're using social media, if your agency is using social media, make sure there's internally clear guidance about the records that are being created there. Next slide. Social media retention methods. Next slide. So social media brings up new challenges respecting records requests. Government email and paper records exist in static form when created. DC government, as we all know, has systems in place to automatically preserve these records. Social media records have characteristics that make it challenging to retain. As I said, it's a fluid environment, so it changes every day. But as we know, FOIA requests are for specific time, places, and dates. So you need to have a strategy for making sure those records are preserved in static form. Next slide. So these are the generally accepted, I guess I would say, how we do it for social media retention. First, take no action. Rely on social networks to retain the records. So as Twitter, Facebook, other social media accounts, once you set up an account, of course, it's there. So if you got a records request and you can't find something, you can reach out to the social media platform to see if they can find it for you. That may pose challenges, and it may not be free. So keep that in mind. The next method is a manual process, like taking a screenshot. That, of course, is effective. If you have a meeting that's going on and you know that you're creating records, for example, you may want to screenshot the chat that's going on. You may want to screenshot comments or just the general goings on of that day. So if it's a specific event that's happening and you know that you're conducting government business and creating records, you may just want to be proactive as the records officer and go ahead and, again, screenshot what's going on or have someone otherwise keeping a record of what's happening. And the last is using what's known as a social media archiving solution, which is a system that captures your social media content in near real time and preserves it in a separate archive. There are several companies out there that provide this service, but again, it's not free. And if you would like some recommendations about using a social media archiving solution, please reach out to me and I can provide you with the contact information. We as government do not endorse one or the other or say that you should get one, but just giving you information, letting you know that these types of companies are out there. Next slide. So relying on the social networks to capture and preserve social media records assumes that the social media networks will retain all of your content indefinitely. I think we as a government are spoiled with Octo because our emails are kept forever, so it's not necessary to really do anything proactively, and that's really our largest electronic database. But social media is not necessarily that way. If you look at your terms of service, they let you know that they have the ability to make space on their network. So things theoretically in the future may not be there. So keep that in mind. Manually preserving records is inefficient and time consuming, but you got to do it. That's what the law requires. So if you don't want to go out and get a social media archiving contract or some instant to assist you, then you just need to make sure that you have some strategy together as an agency to preserve that record. And again, social media archiving through a government enterprise technology, information technology solution, or third-party service may eliminate issues, but again, we're in a cost-cutting mode as a government, so that may not be the way to go. So next slide. So that's the end of my presentation. Thank you for your attentiveness and for your service as FOIA officers and records professionals. If you have any questions about this presentation, please put them in the chat. Also, the office is available to provide basic FOIA training. If you're still in need of that, we will make sure to give you personal training. We have 2 attorneys with us now. We have our Chief Counsel, Johnny Barton, and we have our attorney advisor, Cherie DeBerry. And just to put out another plug, we have a position open for an attorney advisor. So if you know anyone who would like to join the Office of Upland Government, we currently have a vacancy. Will the link to this presentation be provided at the end? I did not receive anything via chat. I'll link it again. I think, I'll make sure that you all get the link. But it's on our website on www.open-dc.gov, and it's under documents. So I've got another question. What about if the page participant is using obscenities on the page? Great question. Unfortunately, that happens. It is still, to me, I would say it is a First Amendment issue, but for your constituency, it might be something that you want to hide. If you do that, my recommendation is to make sure that you have a written justification somewhere, and that you actually retain it somewhere, so that you have a record of it. But again, yes, if someone has a trail of obscenities on your Facebook page, I would say it's reasonable as a government to maybe hide it. I wouldn't delete it, but there should be a way that you can hide it so that it's not visible. But again, these are novel issues, but the court is pretty clear that this is a public forum. So the next question, can personal social media account be part of a FOIA in DC? Well, I'm going to say that depends on whose account it is and what they're doing with it. If they're conducting government business using that personal social media account, then I would say it is subject to FOIA. I mean, I think that's the court has been clear that that's the main driver, of these records. It's similar to email. So if you're using your personal email, for example, to conduct government businesses, without question, that email is a record, a public record, because it has DC government business. So I think the same is true of a personal social media account. I do myself have a personal account. Twitter is usually where I see all the activity for mine. So I make sure that I have a personal Twitter account, and I make sure that I delineate it from my OOG director account and also from agency Twitter account. So I think, especially if you're talking about government officials, it's kind of a gray area. So if I get out there and I start posting on my personal Twitter account something about government, it might be subject to FOIA, even though I've said, this is my personal account. So it's something to keep in mind. I would say it's a case-by-case basis. So let's see, another question. When you mentioned posting documentation on social media as it relates to originals versus copy, would it be permissible to maybe insert a watermark on the document before posting in social media? I think that's a good solution. Again, it wouldn't be a final document, final record. So I think putting a watermark is a good solution. What is the time frame for retention schedule for FOIA documents? That's going to depend on your agency. So if you'd like to send me more specific information, I can help you find that. But each agency should have its own retention schedule, and then there's the general district retention schedule that applies if your agency has not yet put forth a retention schedule. Are text messages on DC government cell phones subject to FOIA? Yes. If it is, if it's a record conducting government business, I would say yes, it is. We've had that question, and public officials have been required to turn over text messages. I believe what has happened is they had to screenshot it or take a picture of the message, or reach out to the provider to actually provide the messages themselves. But again, it's a written record. I'm a former OCTO Office of General Counsel employee, and I do remember that was an issue that was discussed there. So you may want to reach out to OCTO's Office of General Counsel to find out what their position is. But the chair that I sit in now, yes, I think those are records because they are, if they are discussing public business. Now, if you're sending a text message, hey, what time we're going to lunch, that's not necessarily public business. But if you're discussing something of a substantive nature on text, then I would think that particular text was subject to FOIA. So I'm not saying that it's in of itself a record. It depends on what the content of the text message is. Does Bega use a social media solution, and what do they cost? Yes, Bega uses Archive Social, and I believe it's about $1,200 a year. I have to check. It's not super, it may be more than that. Let me not even say the dollar amount because I don't know, but I don't remember it being, it's not cost prohibitive, I guess. But we do not have a lot of social media activity. So a larger agency, I would assume it would cost more. We're a pretty small agency. But I've only had to use it like once or twice, but it was very helpful, again, in capturing the content in real time. So I did find it helpful. Are there guidelines for DC employees' use of their own personal social media account so they can avoid issues? No, unfortunately, no. I think, again, that's something that is a work in progress. My suggestion is to look to other media recommendations that are out there for employees, such as email, phone, other use of technology. I think kind of technology will fall in the same bubble, so to speak. I hate to say bubble, but as far as information goes, I would just say for your personal social media, especially if you're a I would say more well-known government official, people know who you are and maybe looking to see what you have to say, that you may want to put something on your personal social media that says this is my personal account as opposed to my DC account. I've seen several people that I know have put that there. So I mean, we don't want to curtail your speech in your in your personal life, but just be mindful of talking about your job and talking about DC government issues and DC government policies, because if someone did FOIA request that information, it might be subject to FOIA. But we do work with the Office of Chief Technology Officer on these issues, and we will be issuing an advisory opinion on social media and FOIA that has some recommendations on these issues that I've discussed today. Are agencies allowed to hide or delete a person's comment but not block the use, or does this constitute restricting someone's access to a public forum? I hate to give the lawyer answer. It depends on what's in that. So if it's like the question that I answered before, and someone is hurling obscenities and it's something that may be offensive, then I would say you could make the argument there for hiding it because it may be offensive. But if it's just something that you don't like or it's not flattering, then I would err on the side of just you need to leave it there. I've had it happen to me, and I just had to suck it up. You just have to leave it there. It's part of the public record. So I think in the spirit of openness, if it's related to government business on a government site, you should definitely just leave it there. Leave it alone. Don't restrict them. Are unsolicited or non-responded to texts, emails subject to FOIA regulations? It's going to depend on what it is. So if it's clearly not related to government business, then no. But if you remember from that social media policy that Octo put out, the customer service aspect of things. So if it's government customer service related requests or information, that it may be subject to a FOIA request. Hope that answers the question. Okay. All right. So I think I've got everyone's questions. And I want to thank Ashley Cooks, who's behind the Board of Ethics that you see there. She's been helping me, and she's done a great job of organizing Ethics Week. So I just want to make sure that I acknowledge her and thank you. Thank you all for participating. We're here to answer any questions that you have. We've only got an hour, so we're coming up on the end, but I'm happy to answer any personal questions that you have, any questions whatsoever, and work you through these issues, because again, they're new, ever-changing, and the law is not always clear on what we should be doing in this context. So again, I'll conclude our training for today. I hope to see all of you soon in person one day. I hope you all are well and safe and taking care of yourselves and your family. Thank you, Ashley, is my contact information, and Johnny Barton, our Chief Counsel. And our contact information is on open-dc.gov as well. So stay safe and stay well. And I just also want to thank all you FOIA officers. You all have been doing great during the pandemic. I have been able to say our FOIA officers are responding to FOIA requests, and we're following the law. So thank you, thank you, thank you for all the work, that hard work that you all have been doing, and for maintaining openness and transparency in the district government. Have a great day, and I'll see you guys soon.